Thank you everyone for coming today. My name is Kelly McGee. I'm the president of the Environmental Law Society, and we are so grateful to have four of our fantastic and knowledgeable faculty members here today to discuss some of President Joe Biden's climate and environmental goals. We were talking before this started about how UChicago is really amassing an army of environmental lawyers and professors. So we're excited to finally be able to put their knowledge to work and start the environmental revolution at UChicago. And just to give some brief context for a discussion, President Biden has made abundantly clear that he intends for action on climate to be a centerpiece of his presidency. On his very first day in office, he recommitted the United States to the Paris Climate Agreement, rescinded the permit for the Keystone XL pipeline, and started the process of reinstating more than 100 environmental regulations that were either weakened or rolled back during the Trump administration. In addition, President Biden has committed to addressing the disproportionate impacts of climate change and pollution upon communities of color and has vowed to create high-quality jobs in the clean energy sector. And while environmental proponents are understandably very thrilled by this 180 turn from the Trump administration, Biden is likely to encounter some hurdles in implementing this vision. Just to name a few, fully undoing the Trump rollbacks will probably take several years, and new legislation is likely to be an uphill battle with just a razor-thin Democratic majority in Congress. And so while there are so many different topics we could cover today, we've asked our four faculty panelists to focus on just four. We'll be talking about conservation, clean air and water enforcement, state and federal climate policy, and environmental justice. And for an overview of how this event will work, each faculty member is going to present for 7 to 10 minutes. I'm sure that we'll only scratch the surface of their knowledge, but we'll do our best to keep it on that time frame so that you all have time to ask questions at the end of the discussion. So on that note, if you think of questions while the presentations are going on, you can either feel free to put them into the main group chat. You can also direct message them to Lee Johnson, who's our 1L rep, waving in her corner. And you can also wait until the end of the discussion and just raise your hand and ask directly. But please do be thinking of questions so that we can respond and have a really exciting discussion after the presentations. So I'm going to give just a brief introduction to all of our faculty members in the order that they will be presenting. I don't have time to cover all of their many accomplishments, but they are all doing incredible work. First, we'll hear from Professor Hajin Kim on Biden's plans surrounding conservation. Professor Kim uses tools from social psychology to study market-based environmental regulations and private environmental governance. Her current project considers how stakeholder norms can alter corporate pro-social incentives. And Professor Kim is teaching environmental law in the spring and is very much looking forward to having some of you in her class. We'll next hear from Professor Rob Weinstock on enforcement of the Clean Air and Water Acts. Professor Weinstock is an assistant clinical professor with the Abrams Environmental Law Clinic, where he engages in clinical instruction and helps manage the clinic's diverse and cutting-edge advocacy efforts, including a focus on citizen enforcement of the Clean Water Act. Prior to joining the clinic, Professor Weinstock practiced complex litigation at Paul, Weiss, Rifkind, Barton, and Garrison, and environmental law at Barnes and Thornburg, where his practice centered on complex environmental litigation and regulatory support under CERCLA and the Clean Water Act. Third, Professor Joshua Macey will present on legal strategies to harmonize state and federal climate goals. Professor Macey studies energy and environmental law and the ways that financial markets interact with environmental policies. He is teaching energy law and bankruptcy in the spring and is also very much looking forward to having some or all of you in his class. So you can see that this is also doubling as a recruitment effort for enrollment in the spring quarter. And finally, we'll hear from Professor Mark Templeton on Biden's plan for prioritizing environmental justice. Professor Templeton is a clinical professor and director of the Abrams Environmental Law Clinic, where he has taught since January 2012. He has taught environmental law, energy law, and policy, and is currently teaching toxics, toxic torts, and environmental injustice, of which I am a class member. And previously, he was one of 3 trustees for the $20 billion Deepwater Horizon Oil Spill Trust. He also served as the cabinet-level director of the Missouri Department of Natural Resources, overseeing a more than 1,000-person staff and a $310 million annual budget while leading the state's efforts in energy, environmental protection, state parks, and water resources. So now that we have all of our professors introduced, I'm going to turn it over to Professor Kim so that she can give us an explanation of how Biden is approaching conservation in the new administration.
Hi, everyone. So I'm going to talk mostly about the Endangered Species Act in terms of what the Trump administration has done. So I want to talk about, okay, what is the ESA a little bit? What did the Trump administration do? What can Biden do? And what has Biden done? So what has Biden done is really not on the ESA yet, and that's why it'll be more about conservation writ large. But the other three are mostly about the Endangered Species Act, just to, cabin the discussion a little. Okay, so for those of you who don't know what the Endangered Species Act, please take my class in the spring, and also, of course, Professor Macey's energy class. But it essentially, it creates protections for endangered or threatened species. And so the important categories in terms of what the law does for you all to understand today is that there is first a listing decision, which is, do you list a species as endangered or as threatened? So polar bears, for example, are listed as threatened species. Second, if a species is listed as threatened or endangered, then the Fish and Wildlife Service, or NIMS if it's a fish, or if it's, the Fish and Wildlife Service or NIMS will designate critical habitat. And so that critical habitat sort of tells federal administrative agencies, if you're doing something in this area, you need to be very, very careful and make sure you're not going to mess with the species. And third, it says you cannot, for endangered species in particular, you cannot take an endangered species. Take is really a broad word that is meant to cover harm, harass, injure, essentially mess with this endangered species, any example animal of that endangered species. Now, so what the Trump administration did is essentially attack the Endangered Species Act on all fronts. So the context is the Endangered Species Act was passed with really bipartisan support. People were super excited about this. People really talk about charismatic megafauna, so things like polar bears, which kind of capture the hearts and imaginations of everybody, like Americans everywhere. But the Endangered Species Act was very sneaky in that it turns out to be much, much, much more powerful than people had expected it to be. And so it has garnered a lot of backlash where people say, oh my gosh, you're interfering with my private property owner decisions on my land, and you're preventing all this economic development. And of course, there are some conflicts with some renewable energy development too, and there are NIMBY reasons why people will use the Endangered Species Act as a hammer. And so it is kind of perpetually under attack. And so what the Trump administration did was, for listing decisions, one thing that, and if you take environmental law, you'll see that Congress is often fairly deliberate about in what areas can you consider economic costs, and in what areas can you only consider the sort of biological considerations to protect the species or to protect our clean air, or whatever the public harm is. So in listing decisions, in saying, oh, this species is endangered or threatened, Congress explicitly said you cannot take into consideration economic cost. This should just be is this species something that we think is going to be go extinct in the foreseeable future? So two things that the Trump administration did is, first, they said, Robert, okay, you don't have to consider cost, but in fact, you're not allowed to, but you have to compile all the cost information in making the listing decision. We're not going to look at it. But you have to consider, compile all that information. And so people are saying, well, if you compile all that information, of course you're going to look at it. So that's one of the regulatory changes. The second is that, so in light of climate change, one thing that's really, climate change is going to disrupt habitats. It's going to, the most sort of famous and charismatic example is that there's going to be a lot of sea ice loss, and so a lot of habitat for polar bears is going to essentially go away. But all of this stuff is stuff that may happen in the future, and that's not happening necessarily right now. I mean, many things are happening right now too, of course, but many things are just much more predictable, much more predicted than they are currently occurring. And so what the Trump administration said is they redefined foreseeable future as only so far into the future as the services can reasonably determine that both the future threats and the species' responses to those threats are likely. And that was widely interpreted as kind of a don't take climate change into consideration, don't take all these like changing conditions into consideration, just look at the here and the now when you're making these listing decisions. And so that was one line of attack. The second major line of attack was on critical habitat. And here there was a 2018 Supreme Court case on, a lot of times habitats that species will occupy, later there'll be development on that habitat and then they'll no longer occupy that, but it could be habitat for the species that they could occupy if you were to, fix up that habitat from the development. And basically the Supreme Court case kind of punted on the question and sent it down back to the Fifth Circuit. And here, Fish and Wildlife, or the Department of Interior promulgated regulation essentially saying, no, we think critical habitat is only where the species is essentially currently existing. I mean, they couldn't say fully currently existing or periodically existing. So it really limits how much critical habitat you can do. And finally, the other thing that they did that was really huge is there was before a blanket rule that the take prohibitions for endangered species automatically applied to threatened species too, and they basically said, no, we're just going to do a case-by-case basis on when we extend those take prohibitions. There's also a few shady things and maybe I shouldn't say shady, but there are a few really last-minute midnight things that came through. So one thing was they had proposed essentially removing protected habitat for the northern spotted owl in the Pacific Northwest. This is a huge issue because the northern spotted owl protections are up against a bunch of, there's been a long drawn out fight with people who want to harvest timber in that area. And they were originally going to remove something like 200,000 acres of critical habitat in the proposed rule. And then in the final rule that came in January, they were like, oh, just kidding, 3 million acres. Just made the change. Thank you, Kelly, for my time check. I am getting close to the end, so this is good. And the other thing that they did on their way out was, and this is not a regulation, but just like a memo, they said, so under the migratory, for migratory birds, there's separate treaty protection that then is part of a separate statute than the Endangered Species Act, but it has similar protections. And essentially they said there will be no criminal prosecution of birds that are just migratory birds that are injured kind of accidentally. Like if it was not your purpose to kill those birds, the fact that your oil spill killed those birds, we don't care anymore. And this of course is very important because if you don't have that protection in place, then companies are going to say, well, of course I'm not like a superhero villain. Like I'm not like out to just like, oh, how many birds can I kill, right? And if you don't have that intent, suddenly you're no longer liable. So you have no reason to be voluntarily trying to take the precautions that would take care of those birds. Okay, so what can Biden do? And by Biden, I mean the whole administration plus Congress now that there's arguably a Democratic majority in the Senate as well. So he could do something using the Congressional Review Act, which I don't know how many of you are familiar with this, but basically if a regulation was passed within the last 60 legislative days, then Congress can come in and basically say, with no filibuster, this is not subject to filibuster, basically say, oh, we're just going to overturn that. And we're just going to overturn that. And you don't have to go through the whole rigmarole of promulgating a whole new rule. So that's really fast and quick, but really hard to do. So for some of the sort of midnight things he did, for the midnight regulations that came out, like the northern spotted owl, he can do that. For the legal regulations or the legal guidance memos, which is basically just the Trump administration saying, we think X, he can just himself say, well, we think not X now. So that's a little bit easier. Okay. Kelly asked me to talk very briefly about what an executive action is, and I feel like this is a good segue. So, so you have the Constitution. The Constitution is stronger than a statute. The statute is stronger than the regulations that the agency promulgate. And then you have things like guidance documents and legal memos and executive orders. And those are basically just the administration saying, we think this is how this kind of thing has to work, but they have much less legal force than all the things above, and they can't override any of the things that are above them, if that makes sense. right? So what Biden has done since he has come in is issued a set of executive orders. So it's not very strong, but it's saying, here are my commitments, here are the things that I want to do. And in doing them, in issuing them, a few are really important for conservation. So the first is he has said we want to create a civilian climate corps, which is super cool and harkens back to the like FDR's conservation. He had a conservation corps that did basically reforested and built like infrastructure and did like really cool things. Was also racially and racially segregated and sexist. There are only men, so like hopefully we can update some of those things. But it was a wildly popular program and did a lot to sort of instill. And you know, the folks who actually participated in it saw like lifetime health and welfare benefits. The second thing that he did, which is even more important and interesting and just like so exciting, is he committed to what conservation is called 30 by 30, which is he said, we want to conserve 30% of the US lands by 2030 to protect species. So E.O. Wilson has basically said, we need to eventually get to half Earth, where half of the Earth's area is conserved for species and not for humans. And this would obviously sort of get us a long way there. Right now, 26% of coastal waters and 12% of the land conserved is in the US. So we have a long way to go, but it's a very exciting target. And I feel like I've already way gone past my time. So I will cede the floor. Thank you, everyone.
Yeah, no, that was wonderful. And thank you so much for explaining sort of how the executive orders work. I think that's really how Biden has kind of come out at the start, but we'll have to see how those are translated into legislation down the road. And so now shifting to Professor Weinstock, we'll talk a bit about enforcement of the Clean Air Act and the Clean Water Act. So take it away. And I know you have slides, so feel free to take over the screen.
Thank you. Thank you, Kelly. And thank you, Professor Kim. A lot of what you've said, you'll see kind of trickling through what I'm going to talk about, which is going to be sort of a mile wide and hopefully more than an inch deep, but probably not much more than that given the time constraints today. I want to do three things. First, I want to talk about where we've come from on enforcement. So talk about some longer standing trends in the enforcement of environmental laws. Talk about a few specific policies under the Trump administration that hampered the enforcement of environmental law that we can expect to go out the window. And indeed, some of them already are going out the window under the Biden administration. And then finally, offer a couple examples of spots where I believe of sort of substantive areas of focus on enforcement. So let me see if I can get this up. Great. So what you see here is somebody else's figure, but it's helpful. This gives you a sense of civil enforcement actions initiated over time and concluded. You see those lines are basically overlapping, which makes sense. You conclude the ones you start. And you see the trend from the beginning of the Obama administration in 2009 has been downward the entire time. So I think the key here is like many things where progressive advocates are pushing Biden to go further and be bolder, going back to 2016 might not necessarily be enough for many folks. This slide shows inspections and evaluations of facilities. You see a very similar trend line, right? I should note these first two slides are from US EPA's own data. Why is that important? Well, you can't have enforcement unless you have inspections and evaluations to understand when facilities are violating the law. I'll note here also that criminal enforcement, as Professor Kim mentioned, under the Migratory Bird Act, criminal enforcement more broadly under the environmental statutes has bottomed out during the Trump administration. 70% fewer Clean Water Act prosecutions than under Obama, who was even lower than the Bush administration. 40% fewer criminal prosecutions under the Clean Air Act than the W. Bush administration. And there's been a focus on some sort of niche areas, the biggest being disinfectant registration under FIFRA, which has obviously been a huge problem, huge issue in COVID and something that needs to be enforced. But you see the numbers that are there for the Trump administration on criminal enforcement have come in very specific areas. Wildlife trafficking happens to be another, probably sort of the Tiger King bump or something like that. What does this all mean for penalties and deterrence of environmental enforcement? So here you see some numbers from up to 2018. And it's a little bit tough to see because you can see some of these big mega cases kind of swell the penalty figures sort of in the last, in 16 and 17. This next slide gives you a sense more over time. This takes out kind of the mega cases, and also just goes to 18. You can kind of ignore for the moment the different colors, although we could talk about that at length. This slide talks about cost of compliance. So how much are polluters actually spending to fix the problems they've created? This all nets out to some really stark statistics under the Trump administration. In the fiscal year that ended last September, so the last one that there's sort of full data for, the EPA had the lowest number of cases concluded in 20 years, the lowest number of cases referred to for prosecution in 20 years, the lowest number of inspections in 20 years, and the fourth lowest amount of cost recovery in Superfund cases, so where you go after polluters to actually pay for cleaning up had the most contaminated sites in the country. So, the trend has been long and downward, but I think we can safely say, I think we can hopefully say it hit rock bottom. One thing, these are sort of a few different policies I'll talk about in a moment. The thing to think about here is you can expect it to be rock bottom. The Biden administration, I think, clearly will be moving in the opposite direction, even if the trend doesn't sort of go back to 2009 or wherever it ends up on some of these metrics. It's going to move in that direction. But enforcement shifts take a lot of time. As I mentioned, you may have to do an inspection, you need to build enforcement cases, so it's not going to happen overnight. Although I will say there's been anecdotal evidence that it's already happened even during the transition period in November or December, where folks in private practice have reported an uptick in new cases being referred, an uptick in information requests from agencies. Already you saw the career staff sort of saying, oh man, we're going to be unleashed. Let's start to look for new targets. I think that's fair to say, although obviously anecdotal. You also saw some big settlements get rushed through before the change in administration, where I think defendants said, we're not going to fight over the I's and dotting the T's. We've really got to get this done before a new administration comes in. So you saw some big settlements announced in January. Okay, so it takes time, but it is sort of a directional shift. And the other thing that's interesting about enforcement, and it fits into what Professor Kim just said, is this is an arena where executive policy and policy documents tend to drive the outcomes more so than legislative change or even regulatory change. New laws, new regs, they can change the scope of what's available for enforcement. They can create new responsibilities on private parties, new obligations, but the actual enforcement numbers are driven much more by the sort of softer policies, those lower levels of law that Professor Kim talked about. So here are the policies that are sort of ready to go. This policy on encouraging compliance. For years, US EPA has had national enforcement initiatives that have targeted specific areas that they believe need to be areas of the economy or types of pollutant, areas in the country that need focus of enforcement. Trump administration got out of that business and replaced it with national compliance initiatives that oriented their work and really focused on lowering the rates of noncompliance, which allowed the administration to really focus on correcting sort of small bore reporting violations and easy sort of low-hanging fruit that doesn't necessarily have the most environmental impact, but it made their numbers look better than they were, which tells you something about the numbers we saw a moment ago. That's going to go. We're going to get meaningful national enforcement initiatives coming out very soon, and they will focus on substantive areas, environmental justice, climate, that we're going to hear about, we've already heard about, and we'll hear about more today. Promoting federalism. The Trump administration had a specific policy that they would not bring an enforcement action unless the state that hosted that polluting facility asked for the feds to intervene. That was a big dramatic change from practice over the decades previously, although there's always cooperation between states and the feds. That's going to go. You're going to see the feds targeting bad actors wherever they see them, and I'm sure hoping to cooperate with states, but certainly not waiting for permission. Ensuring due process. There was an effort by the Trump administration to really sort of judicialize or criminalize regulatory enforcement. They wanted to bring in all of these due process protections that we get in criminal cases to help protect regulated industry from just routine administrative citations and that sort of thing. that's all going to go. You're not going to worry about using the federal rules of evidence in an EPA inspection, for example. You're not going to apply Fourth Amendment protections in that case, in that context. Other really nitty-gritty agency practices, like who has to approve when the agencies send out an information request? Who has to approve that request? It had to go through headquarters under the Trump administration, all the way to very senior political appointees. That's going to go back to line attorney authority in the regions. Supplemental environmental projects are a form of relief that DOJ has historically gone after in lots of cases, where the polluter will pay to do something good in their community that affects the actual environmental resource that was impacted in lieu of paying penalties to the Treasury. The Trump administration issued a slew of guidance documents forbidding the use of SEPs and the related idea of mitigation damages or mitigation relief. Those guidance documents were actually rolled back yesterday in a memo that's already been issued that rolled those back. So substantive areas of focus, and then I will step back and let me stop the screen sharing now. EJ, environmental justice and climate, of course, are going to be huge. We're going to hear more about them. Under the Clean Air Act, I think we're going to see a focus on diesel emissions. That ties in with environmental justice, because environmental justice communities are often bearing the brunt of transportation pollution. Under the Clean Water Act, we're going to see a focus on plastics. There's been some cases already in the last few years that have targeted plastics discharges. I think you'll see DOJ getting behind that. There's a whole host of other Clean Water Act jurisdictional questions under the County of Maui decision that came down last year that focuses on when pollutant discharge is within the jurisdiction of the Clean Water Act and the Waters of the United States rule. Those things are going to get clarified, and the Biden administration will add their gloss, which will affect the geographic scope of Clean Water Act enforcement. One last really interesting thing, and then I really am done. The Safe Drinking Water Act, which we haven't talked about much, there, municipalities are the defendants because they are often the ones providing drinking water. There's a really interesting opportunity to use Biden's infrastructure push as in conjunction with Safe Drinking Water Act enforcement to push for really transformative change in the quality of drinking water that's delivered by municipalities. So I'll be interested to see if you see those two things paired together. I've already gone too long. Thank you for bearing with me, and I look forward to Professors Templeton and Macey, and your questions most of all.
Thank you so much. And I know you touched a bit about federalism, but I think that is what Professor Macey will be discussing next, and considering how state and federal climate regulations are going to interact in the coming years.
Thanks everyone for coming. And despite my bad jokes, you should also definitely take environmental law. I actually wish I could take Hajin and Mark's classes. So I have this ambition that I'll talk about 3 things. I may just get through 1, and that's fine. But the interaction between state and federal policies involving generation, federal and state policies involving transmission, and possibly, if I have time, how the federal system of energy regulation interacts with the concept of best system of emission reduction under the Clean Air Act. And hint, if I don't get there, the concept of inside the fence line is a contradiction in terms. So the electricity sector is it's not really controversial, I think, to say the most important component in any serious decarbonization effort. The reason right now, electricity is responsible only for about 28 to 32% of greenhouse gas emissions annually in the United States. But the reason it's so crucial is that any serious attempt to decarbonize the United States, basically the strategy is electrify everything. Electrify residential and commercial heating, electrify transportation, and maybe industrial processes that don't get there. And you're already at about 84% of greenhouse gas emissions, with like airplanes and agriculture being the remaining challenges. So this means that a agency, the Federal Energy Regulatory Commission, and an arcane statute, the Federal Power Act, are really, really crucial for the Biden administration's climate agenda. And this is especially the case given that in the absence of federal climate legislation or climate regulation, it's really fallen to the states to sort of spearhead every decarbonization effort in the United States, with 30 states developing fairly aggressive decarbonization goals, and some, such as California and New York, being extremely aggressive. The challenge for these things, there's a challenge in the absence of federal legislation and a challenge with federal action. The challenge under a Biden administration is that the Federal Power Act distributes regulatory authority over sales of electricity between the states and the federal government. And FERC has authority to regulate wholesale electricity sales, and states have authority to regulate retail electricity sales. What that means in very simple terms is retail sales are sales to the customer, to you and me when we are buying electricity. Wholesale sales are sales to a distribution facility, so from the generator to the entity that transports electricity across transmission lines. And if you think about policies that states or the federal government could take to decarbonize, they inevitably involve both. So if you think about how do you want to decarbonize, you might say, let's have policies for rooftop solar. Let's subsidize nuclear. The state could subsidize nuclear. Let's have a carbon tax. Let's incentivize solar storage, either through the federal government or states. And these examples were purposeful because in the past 7 years, there's been a petition to say that every state residential solar net metering program is preempted by the Federal Power Act, that every state nuclear subsidy is preempted by the Federal Power Act, that laws prohibiting the import of coal are preempted by the Federal Power Act. And some of these have been successful, some have not. For example, a New York and an Illinois subsidy to nuclear plants was found not to be preempted because it was paying not for the electricity, but basically for the carbon-free component. But the challenge, and the reason I think the calculus changes in a Biden administration is that in the event that Biden or FERC or even some states implement a carbon tax, that could be found, and people have written that would then raise another preemption challenge for these nuclear subsidies, because while there wasn't a conflict before, the federal legislation or the federal regulation would create a conflict. So to make this crystal, like a very simple example is a carbon tax. I think it's fairly uncontroversial that right now a state carbon tax would not be preempted, though FERC called a meeting on this question. But what if FERC decided to implement a carbon tax or did it through a grid operator? There's some concern that if there was like a $7 carbon tax, that could be, which is totally way lower than is necessary, that would then preempt like a $40 New York State carbon tax. And so and I don't think that's right, but I think that you can, the fact that these markets are so intertwined will inevitably lead to lawsuits from parties that are dissatisfied with decarbonization policy. And so that I think means two things for this administration. The first is that the structure of these rules really matters, and it's not worth, it would be unfortunate if the way that the current administration structured clean energy rules had the effect of pushing out more aggressive state policies. The second and more technical thing is right now, the way that we buy electricity is there's one energy market and whoever provides the cheapest bid clears first. If FERC is serious about working with states, it should create a clean energy market and that states can voluntarily participate in. And this should be for both energy and capacity. Capacity is like a reliability resource, energy is the actual electrons you send into the grids. And that way, FERC is not, it's saying we're going to structure our markets such that if New York State says we need to buy 40% renewables, there is a market that allows New York to buy from renewables, but before it fills up the rest of its, satisfies the rest of its load meaning basically people who are using electricity in other ways. So the markets FERC sets up are capable of either increasing or entrenching or easing these jurisdictional tensions. And I think one very important thing for generation is that this FERC, there are very specific market structure things that they could do to ease jurisdictional tensions. And the biggest is to create this clean energy market, both for capacity and for energy, that would allow states to satisfy their own clean energy goals while also complying with federal and state initiatives. Because otherwise you'll keep seeing what looks like really will become more and more intractable tensions, especially when you have states like Wyoming that have basically passed anti-clean energy laws that are incompatible with the clean energy laws in neighboring states like Oregon and Washington. So I don't have much time left, but the other thing that I want to spend a little bit of time talking about is transmission. This is everyone's least favorite subject in energy world because it's so numbingly complicated, but it is unbelievably important. And the reason, you can think about why it's important for a pretty simple reason, which is that you can build a gas facility or a coal-fired power plant anywhere. You move the coal on a train and you can then store it. And so you can build it on existing transmission lines. Solar and wind should be built where there's a lot of sun and wind. But unfortunately, that is often not where there's a lot of transmission lines that can bring, it turns out not that many people live in the middle of Arizona where there is a ton of solar capacity, but it's really, really great if you can move that sun to Los Angeles or San Francisco. And to do that, you need to build a lot of transmission. This is doubly important given that the sun doesn't shine 24 hours a day, but it does shine. It will sometimes shine in some parts of the country that are not shining in other parts of the country. So like Hajin is in California. There might be more sunlight here where I am in Ithaca, New York than there is in California. And the more transmission we have, if there's solar available where I am, it can immediately go to Hajin. What's awful from the perspective of the Federal Power Act is that it does not give federal siting authority to FERC. States continue to authorize have the authority to decide who can site transmission. And so, there's no possibility that there will be federal legislation changing this. So the other thing I really hope the Biden administration does is to make creative use of something called Section 216 of the Federal Power Act. Now, there are a lot of different interpretations about how it should do this, but what Section 216 does is it says FERC can designate national interest electric transmission corridors, and it has some very limited siting authority in these situations. There's a terrible Fourth Circuit case called Piedmont that says the word with one time FERC has siting authority is if a state withholds approval, but the Fourth Circuit found that withhold approval means deny, not sit on, and so delays don't count. So my two things I want FERC to do are: one, engage in a policy of administrative non-acquiescence, where it ignores the Fourth Circuit in other parts of the country. But two, and I think this is the proposal that hasn't been talked about as much, but is more realistic. Citing authority under 216B, most people, what they want to happen is that the big utilities that require state citing authority are the ones that do it. But people forget that Section 216 has one other part, which says that utilities that don't serve end users in the state can have citing authority. This typically hasn't been very useful because those utilities don't build transmission and states never want to make them do it. But what I think FERC should do is say that when we allocate costs for transmission, we're only going to select bidders that have authority to build transmission. And what that means is the only winners will either have to come with their bids with state siting authority, which will never happen, or the only winners from now on will be merchant utilities who don't serve end users because they get FERC authority. And so it's using 216B. Basically, the idea is there's this provision of 216B that if coupled with, I think it's not crazy to think that transmission should be built by people who have a legal right to build transmission. And FERC can use this end user provision. It's Section 216B2B. Maybe there's a two I's after that. And that, I think there's a possibility, at least I'm hopeful that the current FERC thinks of this as that it doesn't just like vainly or quixotically try to overturn Piedmont, but thinks about other ways to circumvent it.
Thank you so much, Professor Macey. And last but certainly not least, we'll turn to Professor Templeton, who is going to discuss President Biden's focus on environmental justice. And I think that ties together all of the three previous subjects because it definitely is a consideration in all areas of environmental law. So take it away, Professor Templeton.
Okay. Thank you for adding and then lifting, tying everything together to the limited time that I have. But I do think it touches on a lot of different areas. First of all, I think it's important when having a conversation about environmental justice to just start off by recognizing kind of our own situation in this. And so I really do think it's important to acknowledge kind of my very privileged background and position. I think it's important to understand that while environmental justice is generally talking about low-income, people of color communities and individuals, it's actually a really broad movement with many different people and peoples, which have different goals or similar goals, but different priorities in different contexts. And so I really want to be sure to say that if I speak about or emphasize any particular set of issues, that doesn't mean that there aren't many other important ones or other important perspectives as we have this conversation. I'm going to cover 4 points. First, just what do we mean by environmental justice? Second, what has made environmental justice difficult? Third, what has the Biden administration done so far with regard to policies, organization, and people? And fourth, when's the rubber going to hit the road? What are the kind of challenges that the Biden administration is actually going to face? Or in other words, when are we going to really be able to assess whether this is just about pronouncements or actual progress? So first, in terms of what do we mean by environmental justice? Like many things you encounter, right? There are lots of different definitions or perspectives. I think that there are 4 important components to environmental justice. One is distributive justice. So how are environmental burdens allocated, and are they allocated fairly? Recently, there's been more discussion about environmental benefits as well. So if you think particularly about clean energy in that context, it's not just what's the burden imposed by a coal-fired power plant or a local waste-to-energy plant, but are people actually going to get the benefits of solar development in their communities? Second dimension is procedural justice. So not guaranteeing any substantive outcome, but do people who are affected, again, primarily in this context, low-income people, people of color, do they have an opportunity to weigh in on and influence or actually even participate more significantly in the decision-making that's going to affect them? Third aspect is corrective justice. So again, recognizing that we talk about environmental justice because there's been a lot of environmental injustice. How are the needs of these communities and the harms inflicted upon them over time taken into consideration when making permitting and enforcement decisions? So are we actually trying, we, the societal, we, the environmental agencies, actually Department of Justice, actually trying to correct for some of those harms? And then fourth, this has become more, I think, salient because of the past year. How does environmental justice fit into broader social justice movements, right? So again, in terms of the broader needs of people of color communities, tribal communities, environmental justice, where I said as an environmentalist is really important, but I think it's important to understand how it fits into all of these different pieces. Second, what has made environmental justice so difficult? Well, first of all, the obvious systematic racism and abuse of power. Environmental law itself has not been set up well to deal with these issues. While motivated by concerns about public health, the actual implementation of environmental law itself is incredibly siloed, very technical, very engineering orienting, very economic oriented, which really often does not think about distributional consequences. Again, I'm painting with a broad brush here. You can certainly find particular provisions in different laws which are more considering of these, but the agencies are siloed, very focused on what goes on in an industry and what an industry can achieve. there's been a real loss of a focus from my perspective on people, the individuals and communities. And certainly the political environment we've faced the past 4 years has not been particularly helpful either. What is the Biden administration? And so to that extent, I'm actually not going to talk much about what the Trump administration has done because they didn't do much, if anything. So I'm going to talk about what the Biden administration has done. First of all, from the policy dimension, there were a number of executive orders which addressed issues relating to environmental justice. Some of the orders are about climate, are very much climate and environmental justice. So the executive order on protecting public health and the environment and restoring science to tackle the climate crisis talks about how the federal government must advance environmental justice, should be guided by science, that the administration policies, section 1, right? The most important thing, right? Biden administration's policies to, quote, prioritize both environmental justice and the creation of well-paying union jobs necessary to deliver on these goals. Talking about how these jobs are necessary for building a clean energy economy, taking disadvantaged communities, which have been historically marginalized and overburdened, and working with them to transform them into healthy, thriving communities. Agencies shall make achieving environmental justice part of their missions by developing programs, policies, and activities. Another executive order on advancing racial equity and support for underserved communities through the federal government talks about how each agency needs to develop a report on whether new policies, regulations, and guidance documents might be necessary to advance equity in agency actions and programs which could include environmental justice initiatives. One of these initiatives is called the Justice 40 Initiative, directs that 40% of relevant federal investments in clean energy, transit, housing, workforce development, addressing pollution need to be directed towards disadvantaged communities. These are all very high level, and so we're gonna have to kind of see what kind of comes out of that. One way of making sure that broad pronouncements actually turn into some action is to make organizational changes and people changes. From an organizational perspective, the White House has created an Interagency Council on Environmental Justice and an EJ Advisory Council, things which have existed in a sense at US EPA, but now at an entirely level of focus of government. And this is actually really important. The Justice Department is going to have an Office of Environmental Justice within it, focusing on enforcement of these issues. There's going to be an Office of Climate Change and Health Equity. So, you know, I'm not quite sure what the Venn diagram is, but I think it's pretty significant and overlapping with the EJ concerns inside of the Department of Health and Human Services. And people are policy, right? Obviously, what the president does and the cabinet officials do, I firmly believe it's the couple of thousand of appointments, political appointments below that, that actually steer the supertanker over time in the direction that you want it to be, particularly vis-a-vis the bureaucracy, particularly in terms of engaging with the states, et cetera. Some very exciting appointments of environmental justice advocates to key roles. Cecilia Martinez, a co-founder and executive director of the Center for Earth, Energy, and Democracy based in Minnesota, is now going to be the senior director for EJ at the Council on Environmental Quality at the White House, which coordinates environmental policy across the federal government. Dimple Chowdhury, one of Natural Resources Defense Council's lead counsels on their Flint litigation, is going to be a deputy general counsel at EPA. Marian Engelman-Lado, another leading environmental justice attorney, is going to be another deputy general counsel for environmental initiatives. Carlton Waterhouse, the head of the environmental justice program at Howard Law School, who's written a lot about this. He's going to be the currently slotted into the deputy assistant administrator for the land. So think of Superfund and other kinds of programs, although it's possible he might get nominated for other things as well. That goes along with the high level nominations for Michael Reagan as head of EPA and Representative Deb Haaland, would be the first Native American cabinet secretary over the Department of the Interior. Very little time left. Where does it go? So where it goes is this just talk? Permitting. Permits allow polluters to pollute, right? how EPA and the states think about the cumulative impacts of pollution on these communities is going to be really the critical piece of promoting environmental justice. So is setting standards that protect communities, again, from the cumulative harms, not just the one-off pollutant in the particular industry, but what's the community going to face, as well as how is, there's my time, as well as how is EPA going to handle complaints that individuals bring about how states are actually enforcing environmental laws. Very exciting, hopeful future, a lot to be worked out in the details.
Thank you so much for really bringing it down to earth and kind of the human impact of what environmental law is all about. I think that's a wonderful way to wrap up the presentations. So I don't know that we've had any questions submitted, but feel free to raise your hand if you have any follow-ups. I'll maybe just ask one, which is, and can be answered by any of the four professors. Oops. But I'm curious your perspective on how you see Biden integrating science into environmental policy, whether that's a shift from the Trump administration, and then touching on some of the things Professor Templeton just mentioned, you know, what are ways that we can infuse environmental decision-making with science, but also sort of like consider maybe non-technical aspects as well in our decision-making process.
So I'm happy to go with a really quick. So I think President Biden has made very clear that he very much wants science to be a real, like a real part of his administration. How he looks at environmental issues, particularly climate change. He is, I think it is a much more welcome environment for a lot of the scientists who have left a lot of these sort of career staff positions that have hollowed out the agencies. But like just in just like one really stark example, there's something called the transparency rule, which essentially said, like, look, when you look at when you try to calculate the costs and benefits of air pollution, a lot of the costs and a lot of the benefits are based on studies, health studies on the effects of PM 2.5, which is particulate matter of a particular size, 2.5. And in those health studies, they're like the these are good, rigorous studies, but participant identifying information is obviously kept anonymous because these are people's health, right? And so you don't want to just like publicize willy-nilly like that, you know, Joe Smith had like this asthma attack or this type of cancer. You just find out that a participant, somebody who was being studied, got cancer, not that it was Joe Smith. And what the Trump administration did under the transparency rule is say, we can't rely on any studies that are not transparent, that don't have people's actual personal identifying information. And like on the surface, that feels very like, oh, transparency, sunshine, we need to know everything. But really what it's saying is, oh, public health studies that we've relied on to demonstrate like what the consequences of this pollution are for decades, we're not going to look at any of that. And so I think one of the, like, hopefully one of the first rules they try to go after is the transparency rule to get rid of that, to say like, no, we really should consider all of the best science that we have.
Yeah, I'll just add very quickly. The DC Circuit overturned the Trump science transparency rule 2 weeks ago, and Biden indicated that he was going to reverse the rule. The other thing that's related to the transparency rule is something called co-benefits, whether the direct cost benefit of reducing mercury is reductions in direct exposure to mercury, or whether you can consider ancillary benefits, say if reducing mercury also has the effect of reducing particulate matter. The Trump administration thought it should not consider co-benefits. It looks like the Biden administration will think of co-benefits. And the third thing is, I think that encouraging public participation and providing support for the technical components for groups that may not have the engineering or economic background is really, really helpful. And FERC's Office of Public Participation, which I plugged in the chat, is a really hopeful and maybe auspicious way to start, because FERC proceedings can be very technical. And providing support for local communities. Like if you were the victim, you know, if you suffered, you know, your relative died of coal ash pollution, but you don't know how to measure the harms of coal ash pollution, it would be nice to have the Office of Public Participation facilitate those kinds of things.
Yeah, I'll add two quick things. One, on the enforcement side, the monitoring requirements on polluters, the technology they have to use to actually do their monitoring, as well as the pollutant specific standards they have to meet for what comes out of their smokestacks and discharge pipes, decades old. So one thing that the administration could do is just update some of these standards to catch up with science and technology in a lot of more basic sort of traditional ways, which could make a really big difference on tightening the levels in the environment. And then the second point is there are a few rulemakings out there that the Trump administration either finished or was close to finishing based on, I would say, less than robust or current science that the Biden administration is probably going to take another whack at. So one would be the National Ambient Air Quality Standards for particulate matter, where the Trump administration did agree to maintain the Obama levels, which come down a little bit, but science really suggests those should probably be driven down further, I think is fair to say. And then the lead and copper rule for drinking water, where the science is quite clear, there is no safe level of lead in drinking water, and yet the sort of convoluted proposal that the Trump administration pushed out in the fall leaves drinking water systems in compliance with some significant levels of lead still in the drinking water and really sort of spotty monitoring. So I think those are some specific examples where science could be injected quickly and effectively.
Yeah, so I would just add, and this is not meant to be contrarian in any way, or don't interpret this as being anti-science in any way, but science can lead to sclerosis. Right? It's kind of, death by studying something too much and like, oh, we've got to get the perfect answer. And until we get the perfect answer, we won't regulate, as opposed to, well, at least we know this much and therefore we should tighten, or we could impose this. Two examples, I mean, one's a bit more historical, but under the Clean Air Act before the 1990 amendments, they regulated like 7 toxic substances. Congress came in and regulated 189 substances are toxic, and really just kind of pushed what everybody knew was the case. And that's just because of the way things had been interpreted by the courts and burdens. I'm not saying that's exactly where we are today by any stretch of the imagination, but again, you don't want science to keep things from moving forward. Second point, I think this may touch a little bit on what Professor Macey was saying also. We've been involved in the clinic, and I've seen other places too, where the agency just has technical expertise, and groups who are trying to get engaged must have technical experts to help them, or they're just going to lose. And yes, the agencies get some deference. I mean, they do get a lot of deference, frankly. But some of the people there are genuinely open to getting new input. And if you actually can have the resources to bring expertise, you can move it along. So again, I'm not being anti-science here. It's just that like the groups need resources to bring other engineering and scientific ideas to bear to improve what happens in their communities.
Thanks so much for all of those points. I think it looks like we are at 1:15, so I don't see any other questions in the queue, but I think this has been incredibly informative and exciting, looking forward to the next 4 years, thinking about some of the changes that will take place. And we all really appreciate you taking the time to share all of your knowledge with us.